Yeah, and I want to dedicate this for the safety and protection of your nephew and my friends. You know what his Hebrew name is?
Yeah, Gabriel Tzvi Ben Ilana.
And Yonatan Yehuda ben Meirav, and my friend Tzvi Stern's two sons, Eitan and Yishai, and others. They have much bracha
And my nephew,
v'atzlacha. And
my
what's
nephew,
his name?
David Israel, Ben Shoshi.
May all of these people have much bracha and atzlacha, and Hashem give them strength to decimate the enemy and come back safely, and help redeem the hostages and others in harm that are in distress.
Amen.
Amen.
So I found it's quite weird. I was looking for something, and in Parashat Noach, which is coming up next week, I just turned to a page and I found something here. It says here, beasts too. It says one of the 10 commandments is not to murder, and this is very topical. Unfortunately, at this hour, this time, beasts. It says beasts are forbidden to kill people, and if they do, they will be killed through divine means. And that comes from the Abarbanel. Alternatively, this passage refers to a person who turns over another to be killed by wild beasts. Alternatively, also it refers to murder and warns that Hashem will not permit a murderer to go unpunished. He will be hunted down by wild animals or by the hand of man. So that is reassuring to us of these savage beasts, or whatever. You can't call them human beings, what they've done to our people and what they still would love to do to our people. They want to kill us because they're Jews. So justice will be done to them. It doesn't bring back the deceased, but they'll get their comeuppance.
Okay, I hope
That's
so.
in Parashat Noach.
I'm so.
Amen.
All right. So Kev, let's get back in the Gemara share. I appreciate that dedication. Made a lot of sense. Okay, so I'm just going to do a little bit of a summary because we entered off on a bit of an odd note. So if you remember that the Gemara continued its discussion about accepting testimony in the absence of the party against whom it is directed. So we don't know if one of the main witnesses has to be present, or if the defendant has to be present, or the plaintiff, etc., etc. But Rav said we can certainly certify a loan document in the absence of the litigant. In this case, we used the example of the borrower, because when somebody produces a loan document against another and the latter denies liability, the holder of the note can't collect on the basis unless he authenticates the signatures of the witnesses who signed it. And it's a process known as document certification. So one of the ways to accomplish this is by having the witnesses themselves attest to the authenticity of their own signatures. Then the court certifies the document by writing beneath the signatures. And they say, we were seated here as three judges, so and so and so and so and so and so, and testified that we witnessed their signatures, so we reinforce it and certify it. So Rav teaches here that if witnesses who were signed on a loan document, for example, wish to travel overseas, or one of them is terminally ill, the plaintiff, for example, and he wants to expedite things because he doesn't know if his children will have all the evidence at the disposal because they don't have first knowledge of the incident. The lender may bring them before the court and have them attest to the authenticity of their signatures, even in the borrower's absence. In fact, if the witnesses seek to travel abroad, the court accepts their testimony in the defendant's absence, not only in the case of a loan certification, but many other monetary cases as well. The reason why Rav specifies document certification is in order to teach that in this situation, the mitigating circumstances suffice on its own and the court not need summon the defendant. In other monetary cases, the defendant must always be summoned. Okay? Now, we were saying in this particular case, there is a dissenting view to Rav, and Rav Yochanan says we may not certify a loan document in the absence of the litigant like the borrower. So we need to understand where Rav Yochanan is coming from. So Rav Sheshe says to Rav Yossi Bar Abahu, I'm going to explain Rav Yochanan's reason to you, because he holds that there was a verse, and we learned this in Bava Kamma, that if an ox that gores habitually has to go to court, the testimony is given against it in the presence not only of the owner, because the animal doesn't understand what's going on, but every sort of defendant has to be animal human as part of the procedure, but it has to be in the presence of the owner because it was he who did not guard it. So where's this? In Shmot, Exodus chapter 21, verse 29, and it refers to the process by which an ox is rendered a mu'atir. You know that. Okay. So the Torah instructs the owner of the ox should come and stand by his ox when the witnesses testify against him. So according to Rav Yochanan, he extends the scope of this principle to include document certification. Although document certification is generally only required under rabbinical law, whereas Rav doesn't extend the principle to such a degree and says that the defendant doesn't have to be there. Whereas Rav Yochanan says this is the principle upon which we base it, and it's much more stringent. So we don't know which way to go. So the Gemara starts the law, and if you remember correctly, Rava said, now before we were talking about Rav's opinion and Rav Yochanan, this is Rava. So Rava said the law is that we may certify a loan document in the absence of the litigant, in this case, guys, the borrower. And even if the borrower stands in court and shouts, don't certify, it's fraud, it's forged, we don't listen to him and we proceed with the certification. Why? Because he doesn't claim to have proof of the document's falsity. His charge is disregarded. However, if he says, listen, there's a legitimate reason why I say it's not true, give me some time until I bring witnesses and disqualify the document. In other words, even after the court has certified that the document was signed by the witness, by having the witnesses re-signed again, and ordered the borrower to pay the debt. If he says there's collusion, in this case, the witnesses actually are in business partnership or friends with the plaintiff, and he can prove it, that, he can show family pictures together, or perhaps he can show that the witnesses didn't really sign the loan document originally because they were in a different location, and there's some form of legitimacy, we give him time in order to prove his case. Okay, so if he comes by the end of the allotted period, he has come. So what we are saying is he has to come before that period in order that the court listens to his claim. However, he has to substantiate it in some manner. So if he does not come back at that time, okay, then we have to wait for him for the following Monday, Thursday, and Monday. So let me pick on any of you. What does it mean, Gavin? This, because you switched on this Monday, Thursday, Monday. What does this mean exactly? How do we work it out?
That's if I remember correctly, that's when they it's when the court happens. That's when the betting takes place. So it takes place.
Okay.
So it happens. If they miss the one, then if it's not the Monday, then they can come back the following Thursday.
Excellent. You hit on the key word there. The following.
And otherwise the following Monday.
Exactly.
But it can't be done in the same week. It can't be done in the
Excellent,
same week. So you come on the Monday, you can't come on the Thursday, you got to come on the following Monday, etc.
Excellent. And I heard that even before Gavin said the word following, Arthur interjected, so both of you guys did great. And I believe Kevin Yurt, he just was polite and he waited.
Aren't they also market days or?
No. Market days are separate to court days.
And that's really people, they do a fast. If a community needs to do a tzom, it's on a Monday or a Thursday also.
Yeah, that's interesting, actually. I never thought about that, but that actually is a good point. I wonder why.
It's not related to this.
We don't know.
The courts convened.
It's possible that we have a fast because we're being judged in Shemaim on those days. The same as earthly courts adjourn, so too does it mimic spiritual, heavenly courts. Very possible.
And Monday and Thursday is also Torah reading, isn't it? That's sure.
Yeah, that's also true.
That's I'm just saying that we don't know why it links, but there seems to be some sort of link there.
There definitely is. So since that's the case, if on the following Monday, Thursday, and Monday, he doesn't come, this is basically giving him like 3 weeks. According to some opinions, it's not 21 days odd, it's actually 30 days. But irrespective of the opinion, if the defendant doesn't come, we write a bill of excommunication against him, and he remains excommunicated for 90 days. Now notice, we're not writing a seizure warrant against him. We're writing a bill of excommunication because those 90 days are meant to be a deterrent. Why is he excommunicated? Because according to Rashi, he didn't pay his debt. So the reason why the court waits 90 days for the lender to collect the borrower's property for payment at the loan, at the point at which the borrower pays, he's released from excommunication. So let me explain to you what those 90 days comprise of. This will seem familiar. For the first 30 days, we do not descend upon his property to collect what he owes, because one could say that perhaps he's occupied with borrowing money to pay the debt. Okay, so we're giving him reasonable time. And then we give him, for the intermediate 30 days, again, we don't descend on his property because we say, look, maybe he didn't find money to borrow, and now he's occupied with selling property or some asset in order to raise the necessary funds. Now, for the last 30 days as well, we will not descend on his property because one could say he found a buyer for his property, but the buyer himself is occupied with obtaining the money for the purchase, because generally a debtor who claims to be unable to pay his debt is given only 30 days, guys, to find the necessary funds. In this case, it's a little different because here the debtor is claiming that he can prove the document is forged. Like, we don't believe him entirely by the fact that we excommunicate him. So we put some sort of external social pressure, and excommunication is no small matter. It's not like people have clicked him off Facebook, but other loans are not extended to him. He could be not allowed to be buried in the cemetery, Jewish cemetery at that time, or in the section where they bury the Cocker Spaniels and German Shepherds. I don't know. It had implications in terms of matches, community. He was a social pariah. So we do that enough to get him to see pressure, because he needs to be part of the community if he needs everything done. You must remember there were ghettos, and generally Jewish people were not allowed to own property by non-Jewish communities nor do business transactions. So to be excommunicated was a very serious thing and could affect him being cut off. But nevertheless, we take his claim into account to allow for at least a delay, the additional 60 days before writing a seizure warrant for him. Okay. Now, this was my particular thing that I didn't understand, and it's just my particular thing. So obviously, if at the end of 90 days he still hasn't come, we write a seizure warrant on his property. I mean, it's not even negotiable. The court writes a document for the lender, and that entitles him to actually enter the borrower's premises and seize his property as payment of his debt, according to Rashi. Now, my question is, if excommunication is so serious, why would people lend him money if you get excommunicated for some really, really bad things. So the first 30 days, it's unlikely anybody would lend him money. Then that forces him to sell his asset. So I'm just not quite sure. They might excommunicate him from the beginning, or they might make it public only after the first 30 days. Because remember, they wait for him on the Monday, the Thursday, and the Monday, the following Thursday, and the following Monday. And they do that, which gives him 21 days. So I think he's given a certain reprieve so that he doesn't become a social pariah in order that he can loan money. And we also learn, according to another opinion, they give him 30 days before the clock ticks regarding excommunication. So I'm sure that they might manage to align the two. Otherwise, definitely nobody's going to lend him money. I mean, if everybody's got on a bad credit check history, nobody's going to lend them money. So I'm not sure, but I think they do take that into account. Now, so that's when he says, listen, I've got a reasonable case that either the document is false or the witnesses were elsewhere, etc. But those words only apply where it says, I'm coming to court. But if he says, listen, I'm not coming, we write the seizure document immediately. Because if he simply refuses to appear before the court, he doesn't claim to have witnesses who can disqualify the document. He hasn't set out forward a countermeasure officially. So since he blatantly refuses to come, it doesn't grant him any time at all, even the period before the 90 days begins. Okay? Now, we're dealing with a slightly different case now. We were dealing there with loans. So we're talking about with respect to a deposit. And there we write a seizure warrant immediately. Why, Kevin?
You said 90 days, just you rewrite the warrant.
No. So we're saying before we dealt with a borrower, now we're dealing with a depositor, somebody whom you deposited an article with. We write the seizure warrant immediately. Why?
If he's mislaid it or be negligent with it.
Okay, but why do we write it immediately?
Because he should have been more responsible. He should have. Is it a paid custodian or a unpaid custodian?
Well, even an unpaid custodian to a certain degree has a certain level of responsibility. Might not be robbery or something blatant, but Kevin's basically answered the question is that there's no excuse. It's not like you're borrowing funds and you don't have the funds. Somebody gave you a laptop. Where the hell is the laptop, guys? It's pretty straightforward.
But also your best. So my answer would have been similar, but it would have been also to the fact that the clock's ticking. Every moment delay, the less chance you're likely that deposit of yours is going to vanish or be eaten or something like that. So you got to. So with the loan, it's different. You're not going to get it back. There's no immediate rush, no urgency as much as that. And with the loan, he's got an opportunity of trying to raise funds in order to repay the loan. Yeah, there's no opportunity to do that. You just want to get that article back before it vanishes.
Exactly. So then, if somebody stole a laptop from you, if you deposited a laptop with Ruvain, then you're entitled to go get a seizure warrant and go and storm Ruvain's house. No question. Time is of the essence. Gavin's right. The longer you leave it. And also, there's no reason to actually grant him time to find funds. He gave an article. It's a laptop. He should give the article back. There's nothing really to discuss. So it is pretty straightforward. So this is important, is that we write the seizure warrant. We make it effective only for collection of the defendant's land, but not for his collection of movable property. Okay, obviously on completion of the 90-day period. Now we're not talking about a case where it's a depositor anymore, or a custodian, let's put it that way. We're dealing with a case of a borrower again. So
why he has no land?
Okay, so firstly, why do we make it effective only for the collection of the defendant's land, but not for the collection of his movable property? You're right. If there are no options, there's nothing to talk about. Then there's nothing we can do. I mean, if somebody owes you money and they have no assets, what are you going to seize, Gavin?
No, I'm saying if they have movables, but they don't have fixed property. That's what I'm saying.
You can, but what is it we're talking about here specifically? Then it'll give you a good answer.
No, well, yeah, we're talking about where the guy does have fixed property. So because he has fixed property, you can't touch his movables.
Okay, but why would you want fixed property?
Well, I presume maybe in this particular case, there's a lien over that property.
Okay, good answer. So if there's a lien over that property, then
Damon, it's quite simple. Okay.
yeah.
Nobody can steal the property away from the piece. It's still staying there. It's not, it can't be moved.
Okay, so that's the correct answer. Is that, Gavin, the whole reason there's a lien on property is that you can't get rid of it under somebody else's nose. And you're right, if there's only movable property, there's nothing we can do. But we're talking about something a little bit unusual here. So say you come to me and say, I owe you 30,000 rand. And you've got a document for the court and you present it to the court. And I say, listen, Gavin, these are all mates of yours that you knew from school. I've never met them before. And the one lives in Cape Town. And when he signed the date, I know it's in Cape Town because he posted something on Facebook and I've downloaded the picture and I've got a snapshot. So the court says, all right, I'm prepared to hear what Damon has to say. Let's see him corroborate evidence. So now, in the meantime, if I've done a seizure warrant and they've taken after the end of the 90 days for whatever the case may be, if they take away movable property from me and you not being honest, then as a defendant, if it proves later that in fact what I'm saying is correct, and I give you my laptop, you could have sold laptops to defray expenses and defrauded me through the court. So the whole reason that in a case where the defendant might have a case, we give fixed property over to the plaintiff, because if evidence comes out later that the plaintiff created this whole fraud, then we can take the land back from the plaintiff. Whereas if we give him a laptop, he could have sold it in the interim and there's nothing I can do. As a defendant, if I prove that your claim that I owe you money is false and that the document is forged or whatever the case may be. Do you see, Gav?
Also clever, very clever point. Yeah, also clever point.
Yeah, so that's the point of the Gemara. So it's saying that's in actual fact the issue, because it says, and when we write the seizure document, we make it effective only for collection of the defendant's land, but not for collection of the movable property, because the lender might snatch away and consume the movable property, and when the borrower eventually comes and brings witnesses and invalidates the loan document, he won't find anything to collect. He'll be unable to retrieve his money. But if the lender has land, we write a seizure warrant even for the collection of movable property. So take, Gavin, this case of you and me trying to defraud, and I say, look, I don't have land. And the court says, not a problem. Gavin, you've got land. So if David gives you his movable property and afterwards the court finds out that it's a fraud, you can seize your land to that value of movable property, find that he gets restitution for your fraudulent document to say he owes you money. So that's an answer to your question, which was a very good question, Gavin. Very good. So as long as one of the parties has land, we're okay.
Yeah.
So the Gemara says, all right, maybe it's not so on the last ruling, because maybe we don't write a seizure warrant for the collection of movable property, even if the lender has land, because we are concerned that the land might deteriorate. Okay, so the Gemara is saying that maybe we're concerned that the movable property will be consumed by the lender and that the land will deteriorate in value, maybe through an act of nature, flooding, whatever. And then if the borrower proves that the loan document to be false, he'll be unable to retrieve the payment that was wrongfully exacted from him. Now that concern is repudiated by the Gemara, because the opinions are that, look, the land is damaged by an act of nature. Whether I had the land at the time as the one party, you had the land, what's the difference? Nature would have taken its course. So it wouldn't have helped if you took it after or before. Do you get what I'm saying? It's still a sensible way to it's still a sensible way to do it. And even if the other party had extracted it, so they would have also been hit by the same natural disaster. What's the difference? So these were just a grumble here and a rectification there. But it still stands that either the lender or borrower has to have a fixed property because it can right this wrong. Whereas a movable asset is a little bit risky. So just a qualification of the last law. Okay. And that is, these words apply only when the borrower, so we say, okay, fine. So when we write the seizure warrant, we have to notify the borrower. So what does that mean? Even after the defendant has been granted all these extensions, the court does not write a seizure warrant until it has sent a messenger to notify him of the situation. Why? Because the defendant will know that if he doesn't present his witnesses immediately, the plaintiff will be authorized to seize his property. That's the bottom line. So he still needs to be aware of it. We give him every opportunity possible. So we're saying, okay, that's great if he's close by, but what if he's far away? So the Gemara says, okay, if he's far away, we don't notify him. Meaning that, you can't evade the law continually. And if he's far away, he's not going to be present and he's not that concerned. So the Gemara says, okay, what if there are caravans of merchants that go to that place where he's located and come back? Because the court, like, say the person's in South Africa, they're not going to send a force messenger all the way to Italy because it's going to cost tens of thousands of rands. So they say through their network, who's going to Italy? Okay, this guy is going to Venice, and the businessman is meant to deliver the summons from that point because he's going to Italy anyway. So we're saying, but then we wait 12 months of the year for him until a caravan goes and comes back. So the court's not going to send its own messenger for the cost. But the reason Bartways, it works out like 12 months, is that although payment will be delayed, they have to reach him and he has a chance to return. Now, you're not exactly going to get on Lufthansa Air and go there within a couple of hours and they've do it on Facebook or Johannesburg Jewish Community Forum where in 2 minutes they can see who's going overseas what, or they can notify the airport, which says, now today it's different. What you do with the seizure warrant is there's a court-appointed attorney in Italy, there's a court-appointed attorney here, the document is delivered, and the sheriff of the court in Italy, as the South African attaché, goes to deliver it, and it's quick. This wasn't the days of planes, trains, and automobiles. So we had to allow like 12 months. But not everybody agrees with that. Why? Because as in this incident where Ravina made Mar'acha. So who's Mar'acha? Mar'acha is the name of the plaintiff, and he made him wait 12 months of the year before writing a seizure warrant for him, until a caravan went and came back from Baychosai, which is the area where the defendant was located. So the Gemara says, look, it's not usually so. In fact, the court generally doesn't wait so long to let the defendant appear. So why did Ravina wait 12 months? Because you can't take the stock standard as the law. Because in this case, Mar'acha, the plaintiff, was a very powerful man. And if the seizure warrant would have reached his hand, it would have been impossible to remove it from him. So what it was saying is that The reason why they waited for the defendant is that if the plaintiff had had land taken over to him before this other person presented their case, and there was a legitimate issue in terms of being fraudulent, there's no ways that they could have even collected the land. Why? Because somebody has to throw this powerful man off his land. He's got security, he's got armed forces, and you just can't extract it from, like, try getting Gaza back to Israel now and taking the land back. It's not so easy, even if we're entitled to the land back. So we're saying generally we don't wait 12 months. It's only when a counsel so powerful as the plaintiff that if the defendant's land is given over to him before he has a chance to defend himself, he'll never get the land back, even though it's land. That's how powerful he is. But generally, it's not the case. We don't wait for a defendant unless the court messenger can go on Tuesday and notify him, and he can come on Wednesday and he stands in court on Thursday. Meaning, whenever the next time the court is in session, that's when he does appear. Okay?
Can I just make a comment? It's not actually just a comment. I would have thought that the borrower is being negligent by traveling when he has a loan coming due when he doesn't have the money for it. So in which case that he should really be punished for that, because he should be local to make sure he can deal with this case.
Okay, so it depends on certain circumstances. And Gavin, I thought about your point. I think it's valid. If he's just evading payment, then the court will immediately, by the way, write a seizure warrant for him. If he hasn't had any legitimacy to say, he has to present a case legitimately why he thinks the plaintiff is not right. And the court has to substantiate that there's merit in it. It could be that the defendant is not necessarily a poor man and he travels for business. So I think what will happen is, as Gavin says quite rightly, that every situation will be taken into account. Is he a ducker and a diver? And we're going to see this in the duck coming up. Does he try and duck? And how, can we even give it to him at certain events like weddings or other things, just so that we can catch the guy? If he's overseas, is there a timeline where we say, listen, you're just trying to get out of any sort of payment, and you're relying on extradition, and we vote against you? So Gavin's right. We have to look at each case and the honesty of the defendant and all the circumstances. So Gavin is 100% right. Guys, on this note, we can